is no standard definition for assault weapon. Such laws typically criminalize the possession and transfer of semi-automatic rifles with detachable magazines, and at least one specified feature, such as a pistol grip, a folding or telescoping sock, a flash suppressor or muzzle brake, or a barrel shroud. Some of the assault weapons laws list the particular banned weapons by names and also ban any copies of those weapons. Now, the main target of assault weapons bans as the AR-15 rifle, which is the most popular rifle in America today. It's owned by millions of people for lawful purposes, including self-defense. Now, while the AR-15 looks like a fully automatic M4 carbine or M16 rifle, it has a semi-automatic firing system like most modern handguns, which means that for every one round fired, there has to be one pull of the trigger. Legislatures imposing assault weapons bans nevertheless have concluded that the AR-15 is just as lethal as its military counterparts, and federal courts have agreed. 4 federal circuits have rejected Second Amendment challenges to assault weapons ban. The District of Columbia Circuit in Heller 2, the Second Circuit in the New York State Rifle and Pistol Association versus Cuomo. Both of those courts applied intermediate scrutiny to uphold the challenge assault weapons bans. The Seventh Circuit in Friedman versus City of Highland Park devised its own test for assessing the disputed ban, the existence of alternative weapons for defense, some disputed evidence that such bans reduce gun violence, and the fact that such bans make some people feel good were sufficient to reject the Second Amendment challenge in that case. Most recently, the Fourth Circuit in Colby versus Hogan took the unprecedented step of holding that the challenged Maryland assault weapon ban was constitutional on the ground that assault weapons, including the AR-15, are not protected arms under the Second Amendment. Now, the court reasoned that the AR-15 is not protected because it is like an M16 and therefore most useful in military service, which, according to its analysis of a particular paragraph in Heller, written by Justice Scalia, that if it's like an M16 and most useful in military service, it is not protected under the Second Amendment. Now, like my predecessor, in the last panel, I'm going to ask some questions here that to set them out at an outset that we would probably circle around to in our discussion time. A couple of 3 or 4 questions here. First, and if you don't get to these in the presentation, we'll come back to them in the end. But first, assault weapons bans are typically upheld because judges think assault weapons are exceptionally more dangerous than other firearms. The question I had is to what extent is accurate knowledge of how semi-automatic assault weapons operate, to what extent is that an essential prerequisite to proper constitutional decision-making on assault weapons bans? In other words, if the courts are wrong about how assault weapons operate, are their legal conclusions about the constitutionality of such bans less credible? A second question is what is the proper test for determining whether possession of a particular type of firearm is constitutionally protected? Is it a categorical test? Is it an interest balancing test? We've heard those terms talked about in earlier panels today. And, or is it I'm sorry, that was the third question I had, is should the constitutionality of assault weapons ban be analyzed with an interest balancing approach or a categorical approach? So question number 2, what's the proper test for determining whether a weapon is protected under the Second Amendment? And then third is the constitutionality of assault weapons bans. Should that be analyzed with a categorical approach or an interest balancing approach? And then finally, existence of alternative weapon choices to the constitutionality of all of assault weapons bans. So those are just some questions that I have for the panel, and if you don't get to those in the presentation, we can come back to them in our discussion. But we're going to start with Professor Rostron down at the end there, and then Mr. Lowy. Mr. Campbell, and then Mr. Lowy will go in that order. So we appreciate you being here today with us and helping enlighten us on this great topic.
Thanks. I'm used to standing while I talk, so I'm going to do it that way. Thank you to the Law Review here and the faculty and the students for the invitation, the opportunity to be here. It's been really interesting to listen to it throughout the day. Obviously, it makes me think about a lot of things. It intersects with a lot of things that I was thinking about talking about on this subject. For example, I really, something that Professor Blocher said on the last panel really resonates with me. I think these are hard issues. I really think they are. I think I tend to think controversial issues are controversial for a reason. If they were easy and just sort of really one-sided, it wouldn't be something that we'd be having an event to discuss, and we wouldn't be talking about these issues for years and years, as people have said. This debate's been going on. The issue of assault weapons is hard right off the bat, even with just the terminology. What is an assault weapon? People disagree about whether is that even a thing that exists? Is there such a thing as an assault weapon? Or is that improper terminology? Where did the term come from? Some people suggest that the term is, on the one hand, propaganda that's been invented by gun control groups for their sort of political purposes. Other times I've seen people suggest, and even people sort of on the gun rights side of thing, I've seen them suggest, no, it's actually invented by manufacturers and dealers. It was a way to sort of hype their products and sell them. So in any event, the term does go back a ways. And the basic idea, I think, of assault weapons, we could agree, is we're talking about, as Professor Wallace said, these are semi-automatic versions of military firearms. So, after World War II, for example, the Soviet Union and its allies essentially adopted the AK type rifle as their standard, military firearm, and the United States eventually adopted the M16 rifle, and these have the capacity, at least, for automatic fire. But manufacturers eventually developed versions of them for the civilian market that were just semi-automatic, meaning they can't fire automatically. They're not machine guns. They don't fire more than one round with a pull of the trigger, but they just fire one round per trigger pull. But nevertheless, otherwise, they're similar to the military weapons. They are meant to imitate the features and the style of the military weapons. So, for example, the AR-15 is a semi-automatic version of an M16 rifle, which would be used by the military. So that's sort of essentially what we're talking about. I'll give a little background here since I'm the first speaker. Some of what I say may be pretty elementary for those of you who know a lot about these issues. Other people, it may be new to you, so maybe it's helpful to lay that foundation as we get going. But I think the assault weapon issue really started to become significant in the late 1980s. In particular, there was a shooting in California. There was a shooting at an elementary school in Stockton, California. A young man used an AK-type rifle, semi-automatic version, I should say, to shoot at children on a playground and killed some of them. And obviously, it was a tragic thing that got a lot of attention. And so, in particular, people in California started calling for the enactment of legislation to ban these and other types of weapons that have this military style or features. And so within a couple of months, California enacted a statute, the Roberti-Roos Assault Weapons Control Act, which prohibited certain weapons. And as Professor Wallace said, most of these, a few other states soon followed. I think New Jersey and Connecticut were a couple of the early ones in the early 90s. And all of these laws sort of have a similar structure, as he said. Usually there's sort of two parts to it. One is just a list. They'll make a list of weapons that they'll identify by name, and they'll say, the AR-15 or the Bushmaster XM-15 or the whatever it may be is, the AK series. Sometimes it's difficult to list them because there'll be different variations and that sort of thing. But in any event, there's some attempt to list weapons by name. And then there's an attempt to provide a more general definition based on the features of the weapon. So the California law, for example, was pretty typical, and the other laws were patterned after it, that it said, for example, in terms of rifles at least, that a semi-automatic centerfire rifle with a detachable magazine would be an assault weapon if it had any one of 6 features that were listed. So they were a pistol grip protruding conspicuously beneath the action of the weapon, a thumbhole stock, a folding or telescoping stock, a grenade or flare launcher, a flash suppressor, or a forward pistol grip. So you'll get different variations of those features in different laws, and it may require only one of the features, or it may require 2 for it to be an assault weapon, but that's the basic idea of how the definitions work. In 1994, Congress passed a federal assault weapon law, so this time obviously at the national level. And rightly or wrongly, it was very controversial before it was enacted and even afterward, and rightly or wrongly, it's seen as having played a big role in the Republican Party being successful in the 1994 elections and the Democrats losing control of Congress. So there's political implications to it. The federal assault weapons ban had a couple of features that made it problematic, even I think for its supporters. One is that it didn't apply until it took effect, obviously, until it was enacted and took effect. And it didn't apply retroactively. It didn't mean that people had to turn in essentially weapons that were already possessed, assault weapons that were already possessed, were grandfathered, and possession of them would continue to remain legal. And so, among other things, that caused a surge of the sales of these weapons in the period leading up to the law's enactment. People either maybe for investment reasons or maybe just for concern that they then wouldn't be able to get these weapons. But in any event, people sort of stockpiled these weapons before the ban took effect. A second feature of it was that the law was undermined, I should say, to some extent at least, by the fact that once you define exactly what an assault weapon is in these very precise terms, then people can produce a weapon that is close to the banned weapons, but not quite. So, if there's a certain feature, the ability to mount a bayonet or something, if that's what made a firearm fit within the definition of an assault weapon, then a manufacturer could make essentially the same gun, but remove that feature. And now, depending on, you can get around the assault weapon definition, in other words, and depending on your perspective, I guess that could be either sort of an unfortunate and sort of shady sort of evasion of the spirit and intent of the statute, or it could be, on the other hand, just an example of compliance. They pass a law and they say that this is prohibited, and so you comply with the statute and you make something else that's not covered by the law. A third feature of the federal law was that it essentially came with an expiration date. For political reasons, there was a compromise, and they put in a sunset clause that said that the law would cease to be in effect after 10 years. It could be renewed by Congress, but at the point when it came up for renewal, Congress chose not to renew it, and so the federal law went off the books and disappeared. And there have been bills proposed in every Congress pretty much since then that would reinstate the federal assault weapon ban or some version of it, but they haven't been enacted. So it remains essentially a state-by-state issue. And at this point, I believe, if the count is correct, that there are 7 states that have an assault weapon ban in effect. There are states that you might sort of expect that have stricter gun laws. Out in the West, there's Hawaii and California. And then over in the East, there's Massachusetts and Connecticut, New York and New Jersey and Maryland, if I'm remembering. All of them. So to some extent, it's a legislative issue. It's a state-by-state thing. Some states have these laws and some don't. And then, in addition, it becomes a court issue as well, because challenges or lawsuits are brought to challenge these laws, so it winds up in the courts. The legal landscape for these sorts of challenges obviously was impacted greatly in 2008 by the Heller decision that everybody has been talking about today. And so, as Professor Wallace was saying, there have been a number of decisions made about the validity of these assault weapons laws, and 4 in particular by the federal appellate courts. The D.C. Circuit, as he said, ruled on the validity of the District of Columbia's law. The Second Circuit, I think, was next. They were talking about New York and Connecticut's laws. The Seventh Circuit ruled on actually a local law. It was the city of Highland Park, Illinois, had an assault weapon ban. And then most recently, the Fourth Circuit ruled on Maryland's statute. And in each case, the result was the same, that the assault weapon bans were upheld. For the most part, I would say the reasoning was also very consistent, with one major exception, which I think Professor Wallace will talk more about in the in the Q&A to follow. The Fourth Circuit was the only one of the courts that found that the Second Amendment doesn't even really apply to assault weapons, that they're not the kind of weapon that would be covered. But other than that, the courts had pretty consistent reasoning, and it's reasoning that you've heard a lot about today through all of these panels, that they apply this sort of two-part analysis for the most part, and the second step of it is a type of intermediate scrutiny. And as you've heard, intermediate scrutiny can mean a lot of different things. It's not sort of a unitary test that only has one sort of meaning. You could define intermediate scrutiny or apply it in ways I think that would be very demanding, and probably no gun law could survive it, or you can apply it in a very mild sort of way that pretty much everything would survive. And in some sense, I think all the level of scrutiny stuff is kind of a distraction, or kind of I get the sense that judges, they know how they're going to decide a case, and maybe they're going to uphold a law, and if they want to do so, they'll use the legal language of intermediate scrutiny to explain why they're going to uphold it, and if they want to strike it down, they'll do so. At the heart of it, underneath the legal talk about different levels of scrutiny and the tests and that sort of thing, I see two basic propositions, and one of them I think you've heard a lot about already today. One of them is basically the idea of being highly deferential to legislative determinations about how to regulate guns. There's just a ton of that in those decisions. And then second, and specific to the assault weapon issue, I think the courts are moved to a large extent by the idea that, look, it's not a huge burden or infringement on anybody's right to keep and bear arms, because if you can't use an assault weapon, you can use some other firearm. I was going to use a quotation to illustrate the deferential attitude of the courts, and it was exactly the one that John Lowy read to you earlier in the last panel. So we thought exactly alike on that from J. Harvey Wilkinson of the Fourth Circuit, his concurrence in the assault weapon case. As he said, he really sort of eloquently said, look, this is really serious business, and we don't want to. We as judges do not want to decide this. We want to leave this to the democratic process. But I think you see that deference not just in the words, but also in what the courts do. And again, you've heard a little bit of this in the earlier panels today. I think it's fair to say that the courts in these opinions more or less take the government's evidence at face value. In other words, they don't look at it and say, well, am I really persuaded by it? What would be the argument, the pros and cons of it, or like I'm going to assess the credibility of it? They more or less look and say, is it plausible? Does the government, are they presenting a plausible, on its face, a reasonable government could think that that's a reason to do this? For example, a lot of decisions cite a study that was led by a criminologist, Christopher Copper, but it trying to look at what the effect of the federal assault weapon ban was on crime. And to me, it seemed like an attempt to do that in as neutral a way as you can. It had a lot, I will say, it had a lot in it that I think the gun control side would want to cite and point to, and there was a lot in it that the other side, the gun rights side of things, would want to tout as well. So it seemed to be a somewhat balanced attempt to assess these issues. And the governments will cite it, and I will say the courts don't then delve into the complexity of exactly what conclusions this study reached or didn't reach, or the fine details of it. They more or less accept that you could rely on it to enact this sort of a law. Another example is trace data. Guns are sometimes recovered in crime and then traced by law enforcement. And some people find that sort of data to be a useful way to try to study the prevalence of different kinds of weapons used in crime. And you could say that assault weapons are overrepresented based on that. There are others who are very skeptical of the use of that data. David Campbell is one of them, who's written. He had very vivid, if I remember right, very vivid sort of metaphor for that. It was like trying to predict the future, looking at the entrails of animals or something. Okay. Is that right? So just very skeptical and pointing out again, it's complex stuff, using this kind of data. But again, courts don't want to get dragged into the social science empirical merits of whether using the trace data, how representative is it, or how biased of a sample it may be, or whatever. They tend to just say, well, the government could rely on this, and it's not an unreasonable thing to do. So there is this sort of very strong impulse to defer to the legislatures. And then, as I said, I think it's joined by this idea that the infringement on the right isn't that severe. I mean, applying this kind of weak intermediate scrutiny might seem like the right to keep your arms is insufficiently protected. But at least in this case, I think judges say, look, you could use another gun. That argument was sort of attempted by the District of Columbia in the Heller case itself. They said, well, if you can't use a handgun, if they're banned, you could always use a rifle or a shotgun. And the Supreme Court said, well, those are two pretty different categories of weapons. There's reasons you might prefer the handgun, so we're not going to buy that reasoning. But in these opinions, I think the lower courts seem to be essentially saying, so you can't use an assault rifle, you know. And to some extent, I will say, I think this is some of the arguments of the proponents of assault weapons, the legality of assault weapons. To some extent, it's their own arguments coming back to hurt them on this issue. They're sort of hoisted on their own petard, because often they will want to make the argument, assault weapons are really no different. They're not any more effective as a weapon. The functioning, they're semi-automatic. The functioning is the same. So there's really nothing special about them, really no reason particularly why they do what a firearm does better than a non-assault weapon or a weapon with a different style would. And courts sort of turn that around on them and say, well, if they're nothing special, then I guess there's no huge harm if they were to be prohibited. So they're sort of boxed in a way that I would imagine is frustrating, that if they are to sort of acknowledge that assault weapons are more effective as a weapon in some way, then that can be used against them to say, well, then the government has a basis for prohibiting them because criminals might want to use them. And if they say, well, they're not really any different, then the notion is, well, then it doesn't really hurt your rights not to have them. So thinking about this issue and looking to write something for the symposium for this collection that we've done, I was trying to think of something new to say. And I thought about something that has come up a few times here today, which is the role that the appearance of the weapons, just sort of the look of the weapons has in this. And I really do think that the military appearance of these firearms is a big part of the controversy about them. It drives people's feelings about them to a large extent. Again, one of the main arguments in all the literature about this by people who are supportive of the right to have assault weapons, that one of their main arguments will be that these guns are being demonized or singled out for prohibition just because of the way they look. It's just a superficial, cosmetic thing, and they'll come up with good analogies, I think, that are they'll say, oh, what if we did that with cars? What if we said, oh, that car, it doesn't really go faster, but it looks like it could. It looks like a sports car, or it looks like a race car or something, and we'd say, oh, that should be irrelevant to the regulation of a motor vehicle, and it should be irrelevant that a gun has a certain sort of style or a certain look to it. And for the most part, at least, I think people on the gun control side of things respond and say, no, it is not merely superficial. It is not just about the looks. It's about certain features which have substantive, material relevance. It's fairly obvious why some of the most military features, if you have a grenade launcher or a bayonet on a firearm, I guess it's easy to see why that has some use. The things like folding or telescopic stocks, you could say, well, that makes the rifle potentially smaller and perhaps easier to conceal. And a lot of the other features I mentioned, the grips and the barrel shrouds and the muzzle brakes and the thumbhole stocks, half the argument would be that it makes them, these weapons, relatively easier to control while rapidly firing a large number of rounds of ammunition. And so whether it's in a military setting or if it was a criminal use of the gun, that it has some relevance to the functioning of the gun. So, and I would suggest that there's truth in that. I think after all, the reasons why the military designs firearms in a certain way, they don't do it just for the looks of it. I think there's substantive reasons why the Army or the Marines or whatever, it's not just for show. So it's not purely cosmetic. But I come back to that I think the appearance of the weapons plays a big role in the way people think about them and react to them. And I know, I'll just say just for myself, I know this is extremely anecdotal, but I try to think about what is, in the base of my mind, what is the first, it's like what do you call it, like a mind association or whatever, or somebody says a word and you're supposed to quickly, without thinking, say something back. And I sort of think about that with different kinds of firearms. If the AR-15, which again looks like the M16 rifle, if I see an image of that, the first thing that comes to my mind for some reason is the Vietnam War. Just whatever. That's the first thing that comes to my mind. So that's, when I see an AK type rifle, I would say the first thing that comes to my mind is the video of Osama bin Laden using such a rifle shooting out in the desert somewhere. And on the other hand, others, what I would think of as sort of the more traditional, older, classic sort of, sporting and hunting rifle, the first thing that comes to my mind is hunting. And I picture a father and a son in some kind of Norman Rockwell painting, and they're out there, in a bygone era, and they're enjoying being outdoors and and deer hunting or whatever it may be. So, so some of these images are, and I think I'm not the only one in the world who has these different associations. Some of them are sort of darker than others. And again, very anecdotal, but it seems obvious to me that there's something at work in the debate over these guns. And I would not contend that they therefore should be regulated solely on the basis of the way they look and the way they make people feel. But I don't think it's totally irrelevant either. I don't think it's totally irrelevant or absurd for that to be a consideration. And I tried to think of some examples of situations where aesthetics or appearances or looks do matter, how they do affect how we think and feel and do things. And so I came up with a few examples I'll throw at you. If you have any others, you're welcome to share them with me. And maybe they'll be in the article and you'll be rewarded with acknowledgement in the little footnote or whatever at the beginning, which is not worth much. But for example, I found studies that show that the aesthetic merits of educational materials make a difference in how much students learn from them. If the colors are nicer and the way it's laid out and stuff, the substance is the same. The substance of the information is the same. But you learn more if it's aesthetically pleasing. Studies have suggested that the number one top factor that influences whether you think the information on a website is credible or not is the visual presentation of it. And again, it shouldn't really matter. It should depend who wrote it and the substance of what it says, but we give a lot of weight to the visual aesthetics of it. There's a sort of a famous study about product design from Japan. It had to do with the layout of buttons on an ATM machine. But they found that even when, again, substantively they really are the same, if one of them is a more visually appealing layout of the buttons, people will perceive it to be easier to use, even if it's really not. And then that perception becomes the reality. Because if you believe something's easier to use, then for you it actually will be, because you sort of convince yourself that it's so. And another example that I came to mind, and this one maybe people could argue the merits of this, but there's been a lot of talk about what is the value of the airport security and that sort of thing that we go through since 9/11 and that sort of thing. And you'll see some people characterize it as a sort of security theater, that it's really sort of, it doesn't actually enhance security and it's just meant to make people feel better. But there are some in that area who study that area who've started to say that's actually a significant value that we shouldn't dismiss too easily, to the extent that you reassure the public, you minimize and prevent them from having irrationally exaggerated fears about the risk of terrorism, and maybe to some extent you deter potential terrorists simply because you've given a credible, even if it's an illusion, it's a credible illusion of security, and it deters the people from attempting to do something they otherwise would do. There is only one place I've found in the court opinions where they've really talked about this, and it's been mentioned a few times. Alan Gura mentioned it last night, and it's been mentioned here today as well. It's this passage by Frank Easterbrook of the Seventh Circuit, where he essentially did come out and say one of the benefits of the assault weapons ban could be in essentially making people feel safer. It makes the public feel safer. It reduces the perceived risk of a mass shooting, and that would be a substantial benefit. And I understand something going out on a limb a bit here to sort of suggest that that's a valid sort of thing. It's easy to dismiss it and say it's just people's feelings. It's not a real thing, but I would contend that it is. I would contend that the way people react and feel about things is that there is some truth in it and that it is of some significance. Going back to the legislative history of the federal assault weapons ban, I did find a few places where it was mentioned that people, law enforcement, heads of law enforcement agencies and some other government officials talked about how assault weapons, part of the issues with them is the way they look, that they're intimidating and that criminal gangs and that sort of thing, they know it and they prefer those weapons because they're more intimidating. And there was actually in there, I found it interesting that one of the witnesses for the other side said essentially the same thing. He was a witness put on by the Republicans on the House subcommittee. And he was a guy from Arizona. He talked about how he had defended his parents' home after a burglary. He was afraid the burglars were going to come back and rob the place again. So he defended the home with an AR-15 rifle. And part of his testimony was that he specifically chose that weapon because of how intimidating it is. He wanted something where if they saw him, they would absolutely not even think about challenging him or using a weapon of their own because his weapon, an AR-15, would be so intimidating. I was also reminded of a case that Dennis Hennigan worked on, and I worked on it as well back 20 years ago. It was a case about a guy who shot in a law firm in San Francisco. It was called Merrill versus Navigar, and he used a couple weapons. Two of them were Tech 9s that were banned in California but available elsewhere. And part of the issue was, did it make any difference? It was a negligence lawsuit claiming that the manufacturer was negligent in the way they marketed and designed the weapon. One of the issues was causation. Did it even make any difference? Maybe he would have just used some other weapon, even if, no matter how they marketed the Tech 9s. And I always was struck by part of the evidence there. It was one of the expert witnesses was a forensic psychologist who studied the thinking of people who undertake these kinds of killings. And he said, look, they don't choose their weapons randomly. They're very methodical about it. They are want to be very sure that they're able to accomplish what they're setting out to do. And so they're fueled by these violent fantasies. And even just an aesthetic thing like the appearance of the weapon can embolden them to attempt something that they wouldn't otherwise have taken. So it's the sort of thing, it's very hard to prove. It's one of these things where you may feel like it is true, but it would be very hard to prove. It is somewhat anecdotal. But I can't help but feel the pattern of events suggests there's something to it. There are these shootings in recent years. Certainly they don't all involve assault weapons, but there are the ones that do. Newtown, Aurora, San Bernardino, Orlando, Las Vegas, Sutherland Springs. There are these sort of audacious sorts of mass shootings that suggest maybe there are people who are inclined to use this type of firearm when they're going to do that sort of thing. Whether the reasons are practical and substantive or psychological, they prefer a military-style weapon. So the question then is what to do about it, and I think it's a hard issue. If I was running gun control policy or something, or I was setting the agenda, I don't think I would put banning assault weapons at the top of the list. I think I'd work on the background check system, and if I was going to work on a ban for anything, I think I would maybe think about large capacity magazines before assault weapons. But some states have decided to do it, and I think that courts are properly deferring to their decision making, and among many other factors there, I don't think it's totally irrelevant or absurd for them to consider the military appearance of the weapons. People often whenever I hear people say, oh, it's just cosmetic, the line that always comes to my mind is I want to say, yeah, but cosmetics is like $1 billion industry. So it's not everything. Cosmetics aren't everything, but I don't think it's nothing either. Thanks.
Well, thank you, and I'd say Professor Rostron's given a very good introduction and I think fair-minded overview of the topic. I'd like to follow up on what he ended with, which is the issue of appearances. Back in the olden days, when handgun prohibition had been the original objective of gun control groups, and as they started out in the 1970s, and then weren't getting that far on the topic. Josh Sugarman, a strategist for one of them, he now runs his own group called the Violence Policy Center, wrote an influential memo saying basically and this was not some secret thing, this wasn't leaked, it was shared publicly, you can find it on the internet now, and there's no attempt to keep it secret. But he wrote a strategy memo which said, the press is getting bored with handgun bans. We've done our best, we've gotten a certain amount, but we need to come up with something new. And so he said, let's do assault weapons. And as he wrote in the memo, the semi-automatic weapons' menacing looks, coupled with the public's confusion over fully automatic machine guns versus semi-automatic assault weapons, anything that looks like a machine gun is assumed to be a machine gun, can only increase the chance of public support for restrictions on these weapons. And of course, he was exactly right about that. When the issue became a big national topic in the late 1980s, public opinion polls were about 3 or 4 to 1 in favor of prohibition. Over the last 3 decades, the further public education has affected approximately 1/3 of the population. So now you ask this ban question, and it's more like about a 50-50 split on the topic. So roughly 25 to 30% of the population has been educated that these guns are not machine guns, that they were in fact invented in 1885. They're nothing newfangled. But obviously the role of public education is incomplete. And partly because it's also another look back, when Dennis Hennigan and I, for example, were arguing about controls on handguns in the 1990s. One of the things we never argued about was, what are handguns? When lots of states have laws, North Carolina included, that treat handguns differently from long guns. And you can find little variations from state to state, but we all kind of know basically what a handgun is, and there's only disagreements maybe at the margin is what if the gun has a 13-inch barrel or something like that. Handguns are a discrete class that are well understood, and handguns are also understandably sometimes targeted for more stringent regulation because they, after all, constitute about 1/3 of the gun supply and yet are used in about 2/3 of gun crimes. The assault weapon issue, however, is very different. And first of all, it's because nobody ever has a consistent long-term definition of what an assault weapon is. What it is in practice, in statute, is the largest category of arms that can be arms banned that can be gotten through any given legislature at any given time, and that varies tremendously. The original New Jersey assault weapon ban outlawed some BB guns, which was actually, that got thrown out on federal preemption grounds because Senator Bob Dole has a federal BB gun preemption statute got enacted in the 1980s. And the early bills, after, as Professor Rostron said, the Stockton, California murders, the bills came out of Congress. Howard Metzenbaum, the leading gun control senator of his day from Ohio, had a bill that would outlaw things like the Colt 1911 pistol, the 7-shot pistol that was invented in 1911 and still in widespread use today, and an excellent gun, but not what people think of when you put a picture of some guy with a gun that looks like an AK-47 and you say we want to ban these, and it turns out, well, besides those, we're also going after the Colt 1911. Representative Pete Stark introduced a bill that would outlaw every gun that was based on a military and police design, which is just about all of them. The synergy between military, police, and citizen guns has always been extremely strong in the United States, and you will be hard-pressed to find many guns in any gun owner's closet or gun safe that don't have military or police design in their roots. As a state senator, Barack Obama voted for an assault weapon bill that, among other, which did not pass, that among other things would have outlawed some double-barreled shotguns. So there is never any stable definition. It's always how much can we ban. And Connecticut banned assault weapons in 1991, I believe, and then they enacted a new ban in 2013. California has gone through multiple iterations of what it calls an assault weapon, and of course the bait and switch is it's always sold as, oh, this is just a ban on 19 types of guns or very few types of guns. It's only on these eccentric things that regular gun owners don't even need to worry about, and now California is moving to the level of outlawing the next proposal, which is sort of to outlaw all semi-automatics, long guns that take a detachable magazine. So these days, one of the common definitions is what's called the features test, as Professor Rostron talked about. And so you can't say, well, we would just want to ban all semi-automatics, which some countries do. Sudan, for example, that wonderful exemplar of civil liberties and human rights, outlaws citizen possession of all semi-automatics, other than the guns, of course, they give to their John Dewey militias so they can kill the Darfuris. But they're technically outlawed for citizens in Sudan and in some other countries. But short of saying we're going to outlaw all semi-automatics, how are you going to distinguish what gets banned from what doesn't, other than list makes and models? But if on the attempt to list things in a generic way, all semi-automatics internally function at about the same rate of fire. I mean, you can find differences of 1/10 of a second from one gun to another, but they're all pretty much the same. So the focus is on things that do not have anything to do with the gun's rate of fire or its firepower. That is, how fast does the bullet travel, how much does the bullet weigh, things like that. These things, which are the most important things in a gun's lethality, don't count. And you can have guns that are exactly identical in their lethality in terms of the power of the bullet and the rate of fire, and one's an assault weapon and one is not. So we're now down to say, it used to be that 2 features were bad, Now it's having one feature. So one feature that's bad, makes a gun banned, is having an adjustable stock. Well, not everybody is the same height. A person who's 5'3" would have a better fit on the gun if she could shorten the stock. And the other person who's 6'7" would have a better fit on the fit of the gun if that person could lengthen the stock. That is, but yet that is supposedly an assault weapon. That's supposedly, according to the Fourth Circuit, something that is efficiently designed for mass carnage. Then you have other things, like does it have threads on the muzzle, the front of the gun, for which a silencer, as it's called under federal law, a sound suppressor, can be attached. Well, those devices happen to be lawful in 37 states and under federal law. It's a very strict licensing system. It takes months to get the permission from the Bureau of Alcohol, Tobacco, and Firearms, but there are many lawful sound moderators that exist, and they reduce hearing damage. They take a gun from about 160 decibels down to about 140, which is still pretty loud and not silent like in the movies, but it makes progress in reducing hearing damage when they're used in hunting, as is lawful in every state where silencers, as they're called, are lawful. It annoys the neighbors less. It certainly doesn't make a gun silent, but the threads allow the attachment of a silencer, and more important, I think, or more commonly at least, they also allow the attachment of what's called a muzzle brake, which means it keeps the muzzle more stable. When a gun fires, there's kind of a sine wave that travels through the barrel of a gun and makes it vibrate. The muzzle brake stabilizes that, which makes the gun more accurate. Likewise, having an additional grip on the gun, so that instead of holding the gun, say a rifle, on the wooden forend like that, you have a grip, which makes it more stable. If we're going to have a society that has guns in it, it seems sensible that we would want lawful gun users to use their guns accurately, more accurately, rather than less accurately. All these things add to accuracy, stability, better function. The Second Circuit, in its case upholding the New York ban, says, well, this shows that these guns are just more lethal, more effective at killing, and so that's exactly why we can ban them. Well, their argument is if a gun's accurate, that makes it worse, and so by the Second Circuit theory, the less accurate a gun is, I guess, the more it's protected, and that is bass-ackwards in terms of common sense and public safety. In the Colby case, I represented the National Sheriff's Association in an amicus brief filed before the U.S. Supreme Court asking that the cert petition be granted. As the sheriffs pointed out, these features on the guns, the type that are banned in Maryland, are why they are chosen by law enforcement, why guns like the AR-15 is almost certainly the most common gun that you will find in the patrol car of a sheriff's deputy around the country. And things that Maryland bans, like a magazine over 10 rounds. If you look on the hips of your deputies around the country, you will find a great many of them have semi-automatic handguns, often 9mm caliber, with a magazine, a standard manufacturer supplied magazine, between 11 and 20 rounds. Now, it's said that these guns, by the Fourth Circuit, efficient instruments of mass carnage, suitable for warfare and not for civilian life. Well, sheriffs and deputies are peace officers. Peace officers do not wage war. The officer you see carrying a gun is not carrying it so he can kill a lot of people quickly, as is claimed in a defamatory way against people who choose these arms for lawful protection. The only reason sheriffs carry these guns is for lawful protection of self and others. They don't carry them for hunting or collecting or anything else. They are purely for defensive purposes. Every ban, of course, includes law enforcement exemptions, which is kind of odd if you believe what the ban says, that these guns are military weapons that are just designed to kill a lot of people at once. I didn't think killing people a lot at once is a good idea just because the government does it with government employees. And of course, that's not how sheriffs are trained. They're trained to minimize the use of deadly force, not to try to kill a lot of people quickly. And when you put out this pernicious myth that law enforcement is carrying instruments of mass carnage for rapid mass killing, that aggravates the current atmosphere of hostility to law enforcement. Of course, every law enforcement use of force, and especially deadly force, should be rigorously investigated. And some of those have been proven to be criminal, and as Professor Reynolds talked about last night, some things that should have been prosecuted or led to convictions have not. And that is absolutely a serious problem, sometimes caused by undertraining, sometimes caused by poor hiring. But the vast majority of law enforcement officers, when they use deadly force, do so lawfully and justifiably according to the law. Not merely, well, you can't convict them beyond a reasonable doubt. They do so properly. And yet we have a lot of incidents where sometimes those lawful, proper, justifiable uses get distorted for various reasons, and that distortion gets replayed in the media, and by the time the truth comes out, the media's lost interest and moved on. And one of the consequences of that has been an increase in ambush attacks on law enforcement officers over the past 2 years. And laws like Maryland's, the rhetoric behind it, aggravate the problem because they tell you that law enforcement officers are essentially like an occupying army. They're carrying military equipment designed for killing people quickly, the opposite of the truth. It is quite true that most, whether you ban guns at magazines of 10 rounds or 15 or whatever, few defensive gun uses involve more than 10 or 15 shots fired. That is absolutely true. It's true for citizens, and it's just as true for law enforcement. And it's also true that the vast majority of law enforcement, in their entire careers of 30 or 40 years, will never fire a single defensive shot. So if that's true, how come all police officers and sheriff's deputies carry these guns? I mean, not every single one carries a magazine over 11 or more, but the vast majority do. Why do they choose to carry these guns when they know it's extremely unlikely they're going to fire more than 10 shots? And indeed, it's pretty unlikely they're going to ever fire any shot ever. Well, for the same reason that everybody should own fire extinguishers. You have things available for emergency use that you hope you'll never need, but if you do, it can be a matter of life or death. The reason that citizens have always looked to law enforcement as good models for the type of arms to possess is because law enforcement arms are selected with care to be good arms for keeping the peace, for civil defense, defense of civil society. And they copied law enforcement officers in the 1870s with a Colt revolver or the Winchester Model 1866, an 18-round gun that was one of the most popular in the country at the time. They're right to do so because those guns are carefully selected for this crucial use. One reason that magazines over 10 are preferred commonly in law enforcement, and the National Sheriff's Association believes that every law-abiding citizen should be able to make the choice to own one, is reserve capacity. As officers are taught, if you're attacked by one guy, well, if you see one attacking you, well, there could be two. If you see two, then there's three. So, and because violent confrontations are inherently unpredictable, they're initiated by the criminal at the time and the place. The criminal chooses, not the victim. The victim will typically only have one gun and one magazine for self-defense available. And if you have an adequate reserve, the 17 rounds in a Glock 17 or the 16 rounds in a Smith & Wesson or the 20 rounds in a Springfield, if you have an adequate reserve, then knowing there's the possibility of more attackers, of unpredictable developments, you will fire more shots in defense, obviously. Even police officers only hit their targets in defensive shootings, which are usually quite short distances, about 20 to 40% of shots. And of shots, the vast majority are not, unlike in the movies, immediately disabling to the attacker and sending the guy flying through a plate glass window. To the contrary, it often takes several or more shots to disable the attacker. And so if you've only got 10 and you've got multiple attackers, you may be out of luck. But if you have the more standard capacity, then you have a better chance of being able to resist or deter. When you enact imposed limits on magazine capacity below the standard size, below the standard guns that are magazines that are typically sold by reputable manufacturers with their guns, then you are risk shifting because you are making the defender fire fewer shots. And when the defender fires fewer shots, the odds are greater that the attacker will succeed in carrying out what the attacker is trying to do, which is injure the victim. It is risk shifting from the magazine bans, risk shift from victims to perpetrators, in the view of the National Sheriff's Association brief. In addition, another reason for having having standard magazines is what's called suppression fire. Sometimes in a situation, you may not be shooting really thinking that you're going to be able to deliver that fight-stopping hit to the target, to the attacker, but you may be keeping the attacker pinned down so that the attacker can't attack other people and is busy keeping away from your suppression fire, as it's called. And there's no doubt that if you have a better ammunition reserve, your chance of being able to shoot effective suppression fire is going to be more effective. Now, of course, it's true, police officers are trained better and go through background checks before they're being hired. And those are all, and if you say, well, it's only because they have such a high skill level that they're capable of using guns like an AR-15 or a magazine with 13 rounds in it, well, I'm a little skeptical of that, but at least that is an alternative argument. Then if we were going to say you have to have extra training, extra background checks, things like that, that would be a whole different issue than prohibition and confiscation, as is now taking place, but for a preliminary injunction currently in place in California. And I think you have to face the dichotomy, is either you think cops and the guns they carry are the same as the Brazilian police, which really does act, or the Mexican army, which does a lot of law enforcement. You either think of police being like that, as an army of occupation, ruling from above, in which case, well, why shouldn't they be carrying machine guns, as they do in France, where street cops carry machine guns in Brazil, carry real machine guns quite a lot. Or you think of them in the American sense of the peace officers as being of the community, not above it, and rule and policing by consent. And if you do the latter, then the fact that every ban includes a law enforcement exception is a tacit acknowledgement that these arms are quite often, for many people, the best, safest, most reliable, superior arms for keeping the peace and defending innocent life in a civil society. Thank you.
Thank you. First, to frame the debate, the only issue here is whether states or the federal government are permitted under the Constitution to restrict or prohibit assault weapons or high-capacity magazines in the hands of civilians, not law enforcement. And personally, I've represented dozens of law enforcement officers, many of their widows where they have been killed, and I certainly don't view them as occupying forces or anything at all like that. There's no one I respect more because they have to face gunfire, often of assault weapons that are in the wrong hands, and they put their lives on the line. And they are highly trained, and they have a very different job than any of us, including those of us who choose to carry concealed weapons to defend themselves. So that's the issue. And by the way, law enforcement led the fight for an assault weapon ban and a high-capacity magazine ban, and law enforcement continues to support assault weapon bans and high-capacity magazine bans, notwithstanding David's brief and that organization's position in that case. And that record is consistent going over decades because law enforcement knows best how these weapons are used. And I want to try to go back to the prism that I suggested in the previous panel to look at this issue through the prism of people, rights, and laws. And first, people. And the market has pretty much spoken on assault weapons and high-capacity magazines because we've seen mass shooter after mass shooter after mass shooter where they could choose what weapons they want to use in order to kill as many people as possible in a short amount of time. And time after time, they have chosen assault weapons and or high-capacity magazines. Sandy Hook, the Aurora, Colorado movie theater, San Bernardino, Orlando, Las Vegas, Virginia Tech, Fort Hood, Binghamton, New York, Tucson, and many, many more. If I listed them all, I would be finished long after 5 o'clock. So that isn't to say that people who choose to own or use high-capacity magazines or assault weapons are mass murderers or of evil intent or anything like that. That is not to say that there are many people who may buy those weapons for target practice, for example. But there's the reality of how these weapons have been used. And there have been studies that show that because the mass killers chose and used a high-capacity magazine and or an assault weapon, they were able to wound and kill more people than they otherwise would. There's a study that found, reviewing mass shootings, that assault weapons enabled 135% more people shot, 57% more people killed. And to be clear, what that means that there are children, first graders in the Sandy Hook Elementary School who were killed. And if the shooter did not have access to a military-style assault weapon or a high-capacity magazine, some of those children would have come home to their parents, and they didn't. So that's an important fact, and I think that's a fact that legislatures, if they choose, can base a assault weapon ban and or a high-capacity magazine ban. And by the way, studies of the federal assault weapon ban showed that it had an effect on the use of those weapons in crime, as did the ban on high-capacity magazines. And when the federal ban lapsed, there was a spike in the use of those weapons and high-capacity magazines in crime. And on the other side, in the Fourth Circuit case in Colby, for example, the court found that there were no incidents in the record of self-defense using an assault weapon. And there were no incidents of self-defense where it was necessary to fire more than 10 rounds. That is, where a high-capacity magazine was needed for self-defense. So again, the legislatures that have chosen to ban these weapons are considering these facts. And it's certainly more than reasonable for them to reach the conclusion that these weapons can be restricted or prohibited. Next, let's talk briefly about rights and be clear about what this right is when people are claiming that their Second Amendment rights are being infringed because of an assault weapon ban or high-capacity magazine ban. Well, the argument is that someone who is allowed under law to amass in this country an arsenal of unlimited numbers of firearms. There is no limit on how many firearms a civilian can own in this country. I'm not saying there should be or there shouldn't be, but it's just a fact. So someone who amasses 100, 500, 1,000, name your number, of semi-automatic firearms. There are countless semi-automatic handguns that are permitted in states with the most stringent assault weapon bans, and also countless shotguns and rifles. So the argument is that someone who can, under the law, amass this unlimited arsenal, including all the semi-automatic handguns, except those covered by the assault weapon ban, but many, many models, rifles, shotguns, that person is claiming my Second Amendment rights are being infringed upon because I am not allowed to purchase the gun that the Sandy Hook shooter used. Or I'm not allowed to buy a 30-round magazine, or maybe the 100-round magazine that the Aurora movie theater shooter used. That is the argument. So I think for good reason, every single court that has looked at this issue of whether there actually is a Second Amendment right that's infringed upon by an assault weapon ban or high-capacity magazine, every single court's rejected it. And I think it's a very simple case. And the grounds are different in some of these cases, but I think it's difficult to make that argument that your Second Amendment rights are being infringed upon given the legal landscape of federal gun laws in America and every state, even those with the most stringent gun laws. And finally, when considering, people and rights, you of course have to consider people's right to live, as I said in the last panel. And clearly, if you go to a movie in Colorado, go to elementary school in Connecticut, go through go to see your congresswoman in Arizona, you have a right to live, and it is being infringed upon not just by any weapon, but by these weapons that are enabling greater bloodshed and greater deaths. And just finally, and I'm going to have to leave early, so I may not be able to join in this conversation. I assume there's going to be some discussion of the common use test, which has been talked about in the courts about whether assault weapons are protected, constitutionally protected, because they are in quote-unquote common use. And the courts, one of the courts, I think it may be the Fourth Circuit in Colby, or maybe it may have been the Seventh Circuit in Highland Park, that rejected this pretty soundly, and I think it really doesn't make much sense, because the argument is that essentially if the gun industry can get ahead of the legislature, which isn't very difficult, they don't move too quickly, and on guns it can often take them 20, 30 years to pass a law. But if the gun industry can flood the market with a product, therefore it becomes in common use, and therefore it's constitutionally protected. You could imagine creating an extremely dangerous firearm, very similar to a machine gun. And maybe it's a gun that's hard to come up with a legitimate civilian need for it, but very easy to come up with a use for terrorists and mass killers. But if you were able to get enough of them out in the market, then legislatures are powerless to do anything about it, even if it turns out they are used to great effect for mass killing. And that is I've always thought a very bizarre argument. I think there's a good reason it has not been accepted by the courts. Thank you.
gentlemen, we want to have a discussion now of some of the things that were put out here. And one of the things that I'm curious about, and I mentioned it at the beginning, and that is to what extent is accurate knowledge of how these so-called assault weapons operate a prerequisite, essential prerequisite, if you will, to proper constitutional decision-making on assault weapon bans. And I want to focus just for a second on the Colby decision in the Fourth Circuit, because under the two-part test that was discussed in the very first panel today, the Colby decision, unlike the Heller 2 decision or the New York State Pistol Rifle Association decision, Colby concluded, it held, that the assault weapons, like the AR-15, are not even protected firearms under the Second Amendment. And what the Colby court reasoned is because these AR-15s are like a military M16, then they are to be included in this category of weapons that are not protected under the Second Amendment, because in Colby's words, they are most useful for military service. So I guess my question has to do with what if the court, how significant is it that the court make accurate factual statements about how much like an M16 the AR-15 is. For example, the court says the AR-15 is a weapon of war designed to be used on a battlefield, but no national military uses a semi-automatic only weapon. And Colby never explains how it can be designed for the battlefield when it lacks the capability for military applications using automatic fire. Colby also says that the rates of fire between a fully automatic M16 and a semi-automatic AR-15 are nearly identical. And in support, the court cites evidence that claims that an AR-15 can fire 300 to 500 rounds a minute, and that a person can empty a 30-round magazine in as little as 5 seconds. Now, I've put thousands of rounds through an AR-15, and I can't fire one 300 to 500 rounds a minute. I mean, that's pulling the trigger some 5 to 8 rounds per second. I don't know that any of you could do it as well. In fact, I asked a friend, a special operations force guy, to see if he could empty a magazine, a 30-round magazine, in 5 seconds, and he couldn't do it. So these kind of, and one of the things what's interesting is the Fourth Circuit twice cited with approval the Colby District Court's finding that assault rifles are essentially the functional equivalent of M16s and arguably more effective. Now, neither the Fourth Circuit nor the District Court explained how a weapon capable of only semi-automatic fire can be more effective on the battlefield than a selective fire weapon, which is capable of both semi-automatic fire and fully automatic fire. So I guess my question is, when you get a number of these factual descriptions of how AR-15s operate, just flat wrong, how does that affect the legitimacy of the court's decision? Are these factual descriptions necessary for the constitutional decision-making process or not?
Go for it, Bruce. It would be better if courts had accurate facts, and they had the opportunity. This was a contested case, so they had reality presented to them by the other side, and chose to say things which are obviously unsupportable. But in putting aside the ability of judges who are generalists have to inquire into a variety of things. So instead of having to become experts or even competent at knowing about something themselves, one thing they can do is just look at what lower superior courts have said. And they could have read the Staples case decided by the United States Supreme Court in 1994, where the U.S. Supreme Court explained that there is a legal difference between the AR-15 in particular, that's what they were talking about, which fires, quote, only one shot with each pull of the trigger, and which, quote, has, quote, traditionally, guns like that, one shot with the trigger semi-automatics, have traditionally been widely accepted as lawful possessions in the United States, and then the court contrasted those with machine guns, such as the M16 rifle, and which the court ascribed to having a quasi-suspect character we attributed to owning hand grenades. And that's why it was a mens rea case on the state of knowing a malfunction of a gun. So the Colby en banc, I presume their clerks are clever enough that they presented this issue, this quote, well, and it was also pervasive in the briefs. So the Colby court knew about it and obviously chose not only to ignore the laws of physics regarding the firearms in question, also ignored what the Supreme Court had said exactly on this point, which happened to be the central point of their whole argument is, oh, these are military guns. They're just like machine guns, which the Supreme Court has already said, no, they're not.
Well, one, I don't know offhand whether those statistics or numbers are right or wrong. I also don't know, for example, whether they were considering if a shooter was using a bump stock like the Las Vegas shooter did, which does enable semi-automatic guns to fire very, very close to automatic fire rate. And I don't have those numbers on the top of my head to tell you whether those are faster than the numbers in Colby or not.
The Colby numbers are not bump stock numbers. I'd agree with you on that issue.
Well, I think it's certainly proper to see whether somebody using a semi-automatic AR-15 and using accessories that were available to the general public, like bump stocks, can fire at that rate. And so my sense is the numbers maybe aren't wrong, at least if you consider that. But I also think legislatures should be the ones making these determinations more than courts. And so the real issue is, was there sufficient basis for Maryland to enact their law? I don't think the Fourth Circuit or any other court should be engaging in a fact-finding mission and having their clerks go to the shooting range and get their stopwatches out. The legislature has got to analyze this, and then the court is not even considering whether they agree with the legislature, but it's whether there's sufficient basis under the appropriate constitutional standard.
Thought that part of the Fourth Circuit's decision surprising. I mean, to be honest, I thought it was a little bit of a stretch for them to conclude, even setting aside the factual issues that you're talking about. Just to be perfectly honest, even reading from more of a gun control person's perspective, it wouldn't have occurred to me that that's what the Supreme Court meant when they said "and the like." It depends a lot on just what they meant by that when they said M16 and the like. I would have sort of just assumed without thinking a lot about it, or without knowing. We don't know what the Supreme Court says other than what they say. But my reading of it in my own mind would have been, I think they mean, military, selective fire, or automatic weapons. And so it was I would say it was an ambitious argument by the by the lawyers for the governments there, which turned out to be successful. I would say, in line with a lot of what's been said today already, probably wouldn't have made a difference. The judges went on to decide the case on alternative grounds anyway of the intermediate scrutiny. So, and I think if you were to argue this to them, like let's say it's an argument for reconsideration, you said, hey, there's a difference between, I think they would say, we know. We said that they're like, we said that an AR-15 is like an M16 except for one thing. And the one thing is that it can't fire automatically. Now you could say that's a really big exception to make, but they would say, but we recognize that. We said that it's like it in essentially every way. It has the same sort of military, it's patterned after it, it imitates it. We regard that as being like another thing when there's really only one albeit a significant one, albeit one significant difference between them. So I don't think you'd change their mind if you were to tell them these facts. I think they'd say, well, we still reached the conclusion we did, and even if we didn't, we'd say intermediate scrutiny would uphold this.
Now, I think the question that concerns me about how they treat the facts, and particularly when the Fourth Circuit in Colby says the evidence in the case was undisputed, and I've read the entire record, the 3,000-page record there, and it wasn't undisputed. And so I guess my concern is are we at this point where judges are simply making decisions on, for reasons other than the evidence, and which gets us back to, I think, what Glenn talked about last night with these class-based decisions or decisions that are for some other reason than their understanding of Heller, and whether the way that they deal with these kind of factual determinations is a reflection on what they think of Heller in that regard. Let me move on to another question, and it was mentioned here, and a couple of you addressed it. How relevant is this, the alternative weapon choices to these decisions? Because Heller seemed to say, in that case, dealing with handguns, that it's not relevant that to the constitutionally protected activity that you can use alternative weapons. Is that different when we come to assault weapon cases?
Well, I mean, what the Supreme Court said in Heller was that, in the view of the majority, handguns were the quintessential self-defense weapon. And since they were holding that there's constitutional right to use a firearm in self-defense in the home, they did not buy the argument that you could ban the use of handguns for that purpose. That's what they held. They didn't make some broader principle about whether alternative weapons are relevant or not relevant.
I do think it's a crucial part of what the court's reasoning is. Again, if Heller would have been different, for example, let's say the District of Columbia had prohibited all semi-automatic handguns, all semi-automatic pistols, but not revolvers, right? Then the District of Columbia would have had a plausible argument. I don't know why they would have written the law that way exactly, but let's say that they did, for some reason relating to maybe the ammunition capacity or something. Although I suppose you could have a revolver with huge capacity if it was large enough. But let's say they did. It would be somewhat harder for the Supreme Court to say that your Second Amendment rights had been as burdened, right? Because you could say, well, you can't use a pistol, but you can use a revolver. And and then likewise in these assault weapons cases, the more David talked about how maybe some people would want to write an assault weapon ban that really was far-reaching. If it got to the point that it essentially prohibited all rifles, let's say, then the argument does become more compelling, that it starts to look like Heller, and you've prohibited the use of a certain class of large class of weapons. The more narrow and specific it is, and again, especially when the definition of assault weapons is so precise and technical, and you can have a firearm that seems awfully, we talk about what's like, it's awfully like the banned weapon, but it just doesn't have, bayonet mount or something. I mean, it just doesn't have that, but it's otherwise the same. Then yeah, I think that's, you could turn that around on the government and say your distinctions in the statute that you're making are pretty arbitrary, but courts don't seem inclined to do that because it's almost a sort of rational basis scrutiny sort of argument. I just think the distinctions you're drawing are irrational, and you're banning one kind of weapon and not another, and there's really no difference. But they seem to be willing to give the government leeway on that because, again, you can turn it around and say it really doesn't then infringe the Second Amendment all that much. You just can't. There's a constitutional right to have a gun, but not a gun that looks a certain way or that imitates a particular military firearm that looks like you would like your gun to look like.
I think Heller very pointedly did not get into the social science pro and con that my brief did for a bunch of law enforcement organizations, and Justice Breyer cited my brief and the Brady Center's briefs and others about saying, hey, look, there's on all these contested social science issues, on guns, and handguns in particular, and here's what one side says, here's what the other side says, and of course that includes the availability of alternative means of self-defense, of using a rifle or a shotgun instead of a handgun. The majority couldn't care less. What was dispositive for them, once they went through the arduous process of deciding what is the right, does it extend to individuals outside the militia? Once they got through that, it was a very simple case for them, because handguns were commonly the most common arm chosen for defense. And the court went through some reasons, some of which did come from my brief, on why people chose handguns, but it didn't say, oh, that proves they're better. It's just this is why people pick them. And then it goes on, regardless of the reason, people choose. They are the most popular arm for self-defense that people choose. The court deferred to the people in terms of deciding what arms are appropriate for self-defense. And that was the end of it. And in fact, Justice Stevens in McDonald accurately characterized McDonald, the Heller case, exactly that way. He said the court didn't rule on the basis that handguns were the best guns for self-defense. It said the court upheld, or that they're frequently used for self-defense. The court ruled on the basis that handguns are the arm that is chosen the most for self-defense. And so I do think that following, and like Justices Thomas and Alito, that following that what Heller said, you can regulate but not prohibit arms that are commonly, as Heller says, typically possessed by law-abiding citizens for lawful purposes. And this, I think, actually solves the hypothetical of what if the gun industry floods the market with some evil neo machine gun, and they flooded the market before legislators can act, and now we're stuck with common use and you can't do anything about it, at least in terms of banning them. We actually had that experiment, and this is what Easterbrook's opinion in the Highland Park case resolutely overlooks, is machine guns were invented in the 19th century, but were very heavy, mounted on a tripod, extremely expensive thing. And then in the 1920s, Thompson invented the submachine gun, which was more affordable and more portable. And that gun quickly became a hit with gangsters for shooting each other in alcohol prohibition wars. But as the history of John Ellis's Social History of the Machine Gun book says, commercially, the gun was a flop.
Interrupt for 1 second.
Yeah, go for it.
I've got to leave.
Okay.
So David will make my arguments for me from now.
Okay, thank you. Sounds good.
Good hand.
Thank you very much.
Yeah, the Thompson submachine gun was at its, as of 1923, completely unregulated in any particular way. And it never sold because people didn't want it. So that is the solution. You don't have to worry about the evil gun industry being able to flood the market because you can shove things, I suppose, into wholesalers with the appropriate discounts. But if people don't want to buy them, they're going to be coming back from the wholesalers. Heller and the Second Amendment defer to the people for what arms they choose. And I think, as the Thompson submachine gun example shows, and likewise, people did buy a bunch of grenades or anti-aircraft guns, even at a time when you actually could buy those, over the counter if you wanted to, and you had the money. They've just never become popular. The American people, properly following the good example of sheriffs and other law enforcement, have chosen reasonable guns of moderate power for self-defense.
While Heller did not set forth an explicit test for determining what types of firearms are protected in the Second Amendment, it did talk about things like, are they in common use, are they dangerous and unusual. The Second Circuit and the D.C. Circuit, in applying this two-part test, sort of punted on the first part and said, well, we're not sure exactly how all that works with common use or with dangerous and unusual. So we're going to assume these weapons are protected, and then went on to uphold the bans under intermediate scrutiny. Colby did something different, and that was to base its interpretation upon this particular passage out of Heller where Justice Scalia seems to say any weapons, the M16 and the like, that are most useful for military service. Colby read that to exclude that sort of category of weapons from Second Amendment protection. So what is the proper test? I mean, is there a test? Is there factors that courts should look to?
It's a very difficult question. I think, I thought that was one of the, when Heller first came out, that was one of the things that really struck me about it, was going by the reasoning of a lot of the literature about the Second Amendment that had been developed. This has been touched on earlier in the symposium. If the purpose of the Second Amendment is to deter tyranny, and so the people can fight back against an abusive government, then the weapons that need the most protection, or at least some protection, are the most potent ones. The most potent military weapons would need to be protected. And there are people who believe that that's what the Second Amendment should guarantee, up to anything the government has that the people should be able to have as well, for it to serve its function of deterring and hopefully making it unnecessary to resist tyranny of the government. But as a public relations matter, or as a practical matter for the Supreme Court, that would have been really problematic. Gun control people for years had been using that as an argument against this more expansive interpretation of the Second Amendment, saying, oh, if you were to reach that conclusion, if you were to reach the conclusion that it's beyond the militia and that sort of thing, then people will have a right to Stinger missiles and bazookas and grenade launchers and all these kinds of things. And I thought Justice Scalia finessed that very cleverly with his adoption of this common use thing out of the Miller decision, which he otherwise had no use for, and said that it was a poorly thought out and poorly written decision. But he took that one little bit of the common use language out of it and used it as a way to make the Second Amendment protect, the kind of weapons that are the rifles and shotguns and handguns that are people familiar with, but to exclude all of the more potent military stuff. But it was just I think it was just invented as a way to achieve that purpose, and it didn't even make sense from the very beginning. In the argument, there was a moment where he said, so it wouldn't cover, therefore it wouldn't cover machine guns. And the lawyer for the government said, well, but there's 100,000 some legal machine guns regulated by the National Firearms Act, but nevertheless they're legal. And Scalia scoffed at that and said, yeah, but that's out of 200 some million people in the United States. And that's not a very, is that the test? Then there are a lot of kinds of weapons that are not in common use so I don't think it makes a ton of sense, and I think it leaves lower courts with, one of the things that's striking about the assault weapon cases is nobody seems to have much idea how many assault weapons there are. So both sides will try to cite the evidence about, they'll say, well, between this year and this year, we know there were this many AR-15s sold, so at least that's, but it's, there's just not a lot of information about how many there really are. Obviously, they're more common than machine guns, but nobody really knows, and it seems like a test that doesn't make, why should the constitutionality of it depend on common use? Again, to analogize it to other things, we wouldn't say your freedom of speech depends on whether you say things that are typical of what others say, or you say them in a way that's typical. So I never thought it made a lot of sense, and I don't know how to fix it, and courts seem to be just, for the most part, just kind of skipping over it and going to the parts of the analysis that they can understand better.
I think I'd agree with about 99% of that. I do think the common use test has the advantage of being deferential to the public for their own decisions. But one thing that some courts have looked at in terms of, well, is something dangerous and unusual, is typical law enforcement officers. So the Connecticut Supreme Court unanimously said under the Second Amendment you cannot ban an expandable police baton, because it is a Second Amendment arm. It's not dangerous and unusual. And one of the reasons we can tell that this is, say, different from a blackjack, which is a weapon commonly used by criminals, one of the things that makes it different is because this is commonly used by ordinary law enforcement officers. And the same point in the State v. Yana, the Michigan Court of Appeals struck down a ban on electric stun guns, in part because the fact that they are commonly used by ordinary law enforcement officers shows that they are appropriate defensive arms in civil society and not dangerous and unusual.
Any thoughts about where, if the Supreme Court were to take up this issue, or whether lower courts ought to go with this as far as determining whether a certain weapon is protected under the possession of a certain weapon is protected under the Second Amendment?
I was thinking today during a lot of the other presentations, you know, there was Heller, and then there's McDonald, and then there hasn't been another case that the Supreme Court has agreed to hear. And I was thinking about, I wonder what would be the best case for each side. You know, if I was, you know, a litigator for gun control, what case would I be trying to get up to the Supreme Court? Or if I was a litigator for gun rights organizations, what case would I want to say? I would say if I was working for the NRA or another gun rights group, I wouldn't want to push an assault weapons case to be the one. I think it does have this sort of stigma. I don't think the Supreme Court would want to come out and say, and have that, just even, again, the optics of it and everything, they would not want to come out and say, it would make them, in a lot of people's views, it would make it look extreme, or it would be easy at least to characterize it that way, that it's an extreme view to say, oh, you have a constitutional right to have an assault weapon. So if I was I would bring a case like they were talking about, maybe, you know, a nonviolent felon or something like that. That would be my ideal case from that perspective. But from the gun control perspective, I would say it's a pretty ammunition capacity case or an assault weapon case would be a pretty good case to bring. Now maybe that won't be the one, because again, it's sort of like 4-0, so it's sort of undefeated in the Court of Appeals on this. But otherwise, I would think that would be a pretty appealing case, because again, you do have just this issue. One of the things I put in my article is I've always been struck by how, when I'll give a talk and people sometimes come up afterwards, and they're more people who are into gun rights, so they don't agree with me about a lot of things, and they're probably just trying to be nice and say, oh, you know, thanks for your speech and stuff. But a lot of times they will say, I've been struck by how often they will say, although I really believe that people should have a right to have guns, I don't understand why anybody needs an assault weapon. And I know not everyone feels that way, but I'm always struck by how even for some people who really are into gun rights pretty strongly, even this issue nevertheless resonates with them as something where it goes a little too far, or it just bothers them, or there's something about it that they're not willing. Nobody comes up and says, I really think you should have, you know, I really believe in gun rights, but I think something about background checks. It's never their example. It's always assault weapons. So I think it would be a good issue for the gun control side to push up to the Supreme Court and not for the other.
Well, I think that would be the last question for today. I think everybody has been a long day, and thank you for your attendance here, and I want to thank our panelists here. They've done a great job, and it's always hard to be the last panel of the day because everybody's sort of slipping a little bit at that point. But thank you, and let's give a hand to our panelists.
Good to see you.
And then the speakers that are still here, panelists that are still here, if y'all will stand up for a minute, and we'll just give you a hand as well. And is Spencer here? Yeah, Spencer, come down here. So, I have been able to work with Spencer on this, putting together this symposium, and Spencer has just done an excellent job. And as well as all of the law review people, Stephanie Gum back there, managing editor, and is Cosmo here?
He's not.
He's not, okay, all right. But Spencer's the symposium editor, and he has been coordinating, not only been getting speakers, but also helping coordinate all the details and everything like that. And so we appreciate that very much. Thank you, Spencer.
Thank you.
And you've done a great job.
I'll be brief. I just want to thank everyone. We really want to thank our sponsors and also the panelists. Everyone's been great to work with, and I think it went really well. And just thank you all.
Thank you.